There's many patents on the iPhone, but this is a patent on the design by Apple from 2012. Patent on motorized exoskeleton from Rewalk in 2014. The quadcopter drone patents from 1962. The patent on 3D printing from 1986. Patent on the bionic eye from 2013 from Second Sight Medical. Patent on GPS from 1974 from federal funding at the Department of Navy. You've heard a lot recently about CRISPR because there's been fights over this patent between Berkeley and the Broad Institute. The original patent was from the University of California in 2014. Patent on brain implant from the University of Utah in 2013. Patent that we'll use as an example on graphene from Nanotech Instruments in 2006. Patent on Bluetooth from 2013 with Ericsson. A patent on one version of the self-driving car from 2013. Patent on solar power going way back to 1888 from a solar inventor, Edward Weston. Patent on 3G from 2003 from a company called Universal Mobile Telecom. One of the early patents on virtual reality from an independent inventor, Paul Marshall. So I show these just because we're all tech geeks. It's kind of fun to see past patents and what someone like Popular Mechanics thinks is some of the foundational technology of our time. A few points I'll make about this is all these patents they picked out were just one of many early patents that go into this technology. One of the things we're seeing is there's no longer just a patent on an invention, like maybe you saw with the light bulb or the telephone, that really everywhere outside of therapeutics, what you're seeing is a bunch of inventions coming together to enable some very core world-changing technology. The iPhone example has hundreds and thousands of patents around it. And so for anything you may invent, it's critically important, but it's probably going to be cobbled together with a bunch of other IP in whether technology comes to market. Another thing is for a lot of these patents, they were years, decades, sometimes even centuries before the technology actually came to market, which just shows you how long and hard it is to actually commercialize technology even after someone's come up with just an amazing patentable invention. And the last thing I'll bring up is, in order to get these patents, there's a number of steps that need to take place, and there can be mistakes that are made that can limit your ability to get a proprietary position. And that's one of the things we'll talk about today, is just making sure you know enough so we don't make some of the mistakes that could prevent you from getting a patent that could eventually lead to some world-changing technology coming to the marketplace. So very quickly, what's the type of stuff that can be patentable? For our purposes, you should almost think of anything. Anything that you'd call technology can be patentable in some way. There's a lot of policy discussion right now. There's a lot of cases going to the Supreme Court on what types of things can be patentable, but most of those are edge cases around DNA or certain ways of claiming software. Generally speaking, if it's the type of stuff you're doing as really smart engineering STEM students, it's something that can be patentable if drafted the right way by a patent attorney. So whenever you come up with something that you think may be a step above the state of the art, it's probably worth having a conversation with your PI or your tech transfer office to figure out whether it's something that could be protectable with patent rights. What the law talks about is compositions of matter. So anytime you find some new material, even if it's a combination of known materials, that may be patentable. That's like the patent on graphene. Any apparatus, machine, such as the solar panel, can be patentable, and any process. So the CRISPR gene editing process is a series of steps of doing something that by itself is patentable. And then, very importantly, is any new method using any of the above can also be patentable. So even though the original solar panel technology was patented way back in 1888, if someone found that pointing a solar panel at a certain angle at you could cure cancer, that would be patentable. You would need to show some level of efficacy that actually works to create the idea. But if no one else had thought about that, publicly disclosed that, that by itself could be patentable even though you're using a known apparatus. So a little bit about how you get a patent and what it means to get a patent. This is the face of the patent for that graphene patent from 2006 that we talked about. And the one thing I'll point out here is just how long and hard it is to get a patent, even after you've come up with the amazing invention. So for this patent, they applied for it on October 21st, 2002, and they didn't have it issued by the US Patent and Trademark Office until July 2006. So, close to 4 years, and what probably cost $30,000 to $35,000 of attorney's fees to get this patent. And what does it take to get a patent? Well, if you look at the law, it says it has to be useful, it has to be new, it has to be non-obvious, it has to have an enabling description. So usefulness you can almost just ignore, because anything you guys are working on is going to be useful, and this bar is very, very low. There's only one invention that I know that's been rejected because it wasn't deemed to be useful, and that was this idea for basically a perpetual time machine. And that was almost more of a problem than it didn't have an enabling description. The main ones that we're going to talk about are new and non-obviousness. And new just means that there isn't something that's publicly known that teaches the exact same thing that you think is your invention. And non-obvious is this very confusing legal term that basically means even if you're new, you're different enough over all the prior knowledge that we think this is inventive. And what the patent office or courts look at is, hey, this hypothetical person of skill in your field, would they find that your invention is unpredictable or counter to the conventional wisdom? Universities will normally file what's called a provisional patent application. A provisional patent application is not a cheap patent application. It's not a light patent application. It's not a set of PowerPoint slides. It is a fully drafted patent application that describes your invention and you've worked with a patent attorney on. But that patent application gives you your filing date, and then it lasts for a year. And then within a year, you need to do what people call convert your provisional, which really means file a utility or non-provisional application that claims the priority of this filing date. So it contains the same description generally of this invention. And if you do that, you get the benefit of this filing date. And then it's that application that an examiner at the Patent and Trademark Office is going to examine for 3 to 4 years, costing you or your employer $30,000 to $35,000. Why do people file this provisional patent application? Well, normally in most spaces where you're still years from getting the technology to market, and that's true for most university innovations, so you're not in a hurry to get your issued application. You file this because it then gives you a year to learn more about the technology, to figure out how you want to claim the invention and what's the potential commercial application, if you're a startup, to raise money for it, before you file the application that starts incurring expenses because it gets rejected. The other benefit of filing this is that your patent lasts 20 years from the date you file the non-provisional application. And so by filing a provisional, you're effectively adding a year to the length of your patent. If this was the utility or the non-provisional, your patent would expire 20 years from there. And again, for most high-tech technologies, pharma, cutting-edge physical sciences, the technology is going to come to market during the second half of your patent term, and so that last year is particularly valuable. So this is what normally happens. Now, that last slide where I said your invention has to be new and non-obviousness, the newness and the non-obviousness of your invention is judged as of your filing date. So anything that's publicly disclosed before then can be used against you when the examiner looks at your newness and your non-obviousness. Anything that's publicly disclosed afterwards is irrelevant for that purpose. And so the stuff disclosed before, us lawyers or patent people call prior art, but it's more commonly referred to as a public disclosure. And we'll talk about that in a bit, because the key there is your own public disclosures count as prior art and can be used against you. And so I guess two things. One, you don't want to file a patent that's not patentable, right? No one wants to waste $30,000, $35,000 in 3 to 4 years. And you're going to file a better patent if you actually are aware of the prior art. So search away, because you'd love to find pre-existing compositions of graphene, because now you may focus your patent on the method of making it, or your particular embodiment of the graphene composition. Knowledge is power. And on worrying about freedom to operate, you don't want to go forward with a startup if there's freedom to operate problems, because a competitor has a huge patent portfolio that just dominates that field. Or you can design your product around it, or at least you know that there's a significant IP dispute coming down the road, and you'll be ready for it. So I think for startups in a university setting, there's almost no scenario where you wouldn't want to know about some other problematic IP. Now, go work at a company like Google, GE, And they very well may be telling their employees, hey, don't be searching competitors' patents because we don't want to know about it. Like, we're fully willing to fight the war in court, and we'd rather not have knowledge, and it's not going to change what we do anyway because we're just this monster going forward. So I think there's different advice for different circumstances. For the circumstances here, search away.
Do you recommend us doing the searching? Wouldn't the tech transfer office do all this?
Yeah, so the tech transfer office can do this for you. So when you come with an invention to us, and I'm sure your tech transfer offices too, like, we're assuming that no searching's been done, and we have resources in place to do that searching. If you want to, it can be helpful. There are definitely people that like it, or just that want to know, hey, is this something that I should even report to tech transfer? Like, what's the general state of the art? Like, I think it's an invention, but let me just make sure I'm not crazy. And there are people that do that, but it's not something that you're expected to do. So now coming back to the question of, can I publish and patent? Because now you've just scared me about publicly disclosing. Like, I'm at a university, I want to publish, how do I do this? So a publication before your filing date is going to be problematic in terms of getting your patent. In the US, it starts a 1-year clock ticking to file your US patent, but in almost all other meaningful jurisdictions, a pre-filing public disclosure bars you from later getting a patent. And in most technologies, we care about Europe, we care about other big industrial countries, and so we don't want to publicly disclose before we file. But that doesn't mean don't publicly disclose, that just means don't publicly disclose before you file. And universities now have become very nimble at filing provisional patent applications, so that upon filing, you can now go publish, you can go present, you can do all the things you want to do in an academic setting. So it is not this mutually exclusive choice between publishing or patenting, it's just a matter of sequencing. And when you give your patent office enough time, and normally we like at least 4 weeks, but we can do it in 4 hours if needed, to file a well-drafted provisional patent application, that enables you to do all the things that academics and researchers want to do. So let's talk quickly about software. Anytime you're using software to make technology behave a certain way, there's typically a way to get a process patent on it or a patent on the apparatus that's doing something new because of the software. There's been a lot of discussion recently about whether all this stuff should be patentable and where the line is between patentable software and unpatentable software is changing daily. But the main point for you all is that software, whether patentable or not, is valuable IP. Because even if the machine that the software is operating isn't patentable, the source code behind it is absolutely copyrighted and potentially a valuable trade secret. And whether it's patentable, copyrighted, protected by trade secret, you can let the attorneys figure that out, but that is something that would be an invention that you want to work with your tech transfer office on. Open source software, I'll just mention quickly. Almost all universities are very open to releasing code through an open source model, so if that's something you want to do, I think universities are there to support you doing it. The real issue with open source is on the input side. So open source software is not free software, it's not public domain software, it's software that's licensed with certain restrictions attached to it. And so if you take open source code and you use it, you have to abide by the restrictions in that license. And commonly the restrictions say, any code you create that incorporates this open source code also has to be released open source. And maybe that's cool, maybe that's exactly what you want, but maybe it's not, because maybe you're putting that into a product where you have commercial aspirations for and you want to patent it. And many types of open source prevent later filing patents on something that includes it, later licensing it under any proprietary model. So just as you do your work, be careful about using existing open source code. Again, there's resources there to help you figure out what types of open source can be used consistent with commercial aspirations. So coming now to the question about confidentiality and NDAs. So let's first talk about confidentiality issues for you all working on the CELMET project. So you're now working with research that has potential commercial applications. So you just generally need to realize that for a number of reasons, you need to be careful about who you communicate this to and how you communicate it. We've talked about how public disclosures can harm patent rights. you also just need to be aware that some of the information is not meant to be disseminated to people that aren't members. And so that means, things that sound basic but are actually the number one ways that information gets improperly disseminated is just through improper digital hygiene, I'd say. Not having your computer or your personal device password protected is a huge mistake. So if you haven't done it, set it up so that as soon as your smartphone goes to sleep, it takes a password to log back in. That's what's going to save you a ton of time if you leave it in an Uber in New York City over the weekend and lose it. Because when you come back and realize that your work or your graduate student email was on there, anyone that gets it can access all this confidential information of CELMED, that becomes a big problem. And it just takes a lot of time to try to fix that problem. And so password protecting your devices saves you trouble. Not losing your devices also saves that trouble, but I understand no one's trying to lose their cell phone in a Uber in New York City. It just happens. Use university-provided email accounts. And so, probably most of you know this, but there's a difference in protection between kind of generic Gmail and the enterprise, Google email that all of us make available. And when your information sits on servers through Hotmail or Yahoo Mail or something else that's not sanctioned by the university, it's not protected in a sufficient way for confidential information. So only use your university-provided email accounts to transfer information. And then lastly, just be careful with social media.
What about Dropbox?
So my understanding is that Dropbox is not okay for sensitive information. And that's right. So at Michigan, I know we have a special account with Box, and it's because Box has been screened and it's been deemed sufficient for sensitive information, whether that's health protected information or the type of information you're working with on this. But the last time I looked, is that generic Dropbox was not sufficiently safe. So I think at U of M, you'd want to use the U of M sanctioned Google Drive through the enterprise or the U of M sanctioned Mbox account.
How should we be sharing data between universities in a safe way?
So when we wrote the proposal, we had identified using Boston University's server system, which is backed up, stored externally, password protected. We had been talking about using Dropbox, which it sounds like is not a great way to do this. So I think what we need to do is go back to BU's IT department and determine how we can get access for the non-BU students to the servers. And if that's not the case, then we're going to come back to Bryce and we're going to talk with him about Box and maybe connect the IT departments at BU and Florida and come up with a solution.
I have a question about emails that you mentioned. So if you use your BU or your EDU account for all of the communications that you make about a project, but you have email forwarding in place so that you receive emails on other accounts, but you never use that account to email back or anything, is that a problem?
I would say that's suboptimal.
Okay.
Because, if you have sensitive information that's going through your BU account and it's being forwarded, basically what you're concerned about is anything that's putting it on the servers of Yahoo Mail or whatever your personal email account is. And then that's how it could be accessed by some third party. And so I would think you would, for purposes of working on this project, you'd want to turn off that forwarding. So lastly, I'll just talk about working with your tech transfer office. So, at every major research university, like the ones in this room, there's a tech transfer office that's there to help you with these issues. There's some way to easily submit your invention. For us, it's just a click of the button here. You can submit your invention to our office and get assigned someone that can help you figure out, how does the framework of the CELMED agreement work? What can we do to make sure that there's the right patent protection in place before you go out and present this information? This is a general picture of how I think things are set up to work with the CELMED arrangement, where each researcher works with the tech transfer office at their host school. That office can work to figure out how to get the right patent applications filed before you go off and present. And then if that invention is something that was created under the CELMET arrangement, it gets reported to the center IP committee that then can facilitate sharing that information with members because they have certain rights to express their interest in licensing the information, and there's a certain period of time by which they can express that interest and perhaps get a license to the information. But there's a framework in place. It generally is meant to, take the responsibility, the onus off of you, as long as you, recognize the invention and report it to your tech transfer office. But again, you can always ask your PIs for help. You can always ask any of us for help. You can always ask your tech transfer office for help.
Do the member companies have any authority to say, don't publish once they've gotten information about the potential IP?
To my knowledge, no. I think there may be a period of review, or if it's something that they're interested in, there may be like a 30-day review just to make sure there's not sensitive information that's going in. But publication is a fundamental tenet of all our institutions, and so that's something that's absolutely allowed.
I ran into this problem with other centers, so we specifically did not allow the industrial member review,
Okay.
and so it's even better.
So, CELMET is a very long duration, 10-year project. So, during the course of 10 years, many of the researchers will exit the group. They might work with many industries which are not a part of CELMET consortium, or many of them might work with research groups which are not a part of CELMET, but they will have many sensitive or insights into what we have done, or some of the very key knowledge base. So are there any mechanisms in place which makes sure that the things that were done here are not implemented elsewhere, or are not published, or a patent is filed elsewhere outside the CELMET umbrella? Because personally, I don't remember signing any non-disclosure agreement or anything of that sort, but that can be a possibility in a 10-year period when someone can exit the group and go to some industry or somewhere else.
Yeah, good question. Yeah.
If you go somewhere and you're using information that is patentable information, even if you're starting your own company, and based on the knowledge you learn, your company has to license. If it's owned by the university, you have to license it from the university. If you're going to a big company and they have a lot of trade secrets, it's honor system. I'm not sure what to advise you on that. It's honor system. I think it's a more severe issue at corporations, where you are at a corporation and there are trade secrets, and you do sign a confidentiality agreement when you start working at that company. So it's greater issues there, but still, it's honor system.
By nature of the research being done here, that there isn't a risk of valuable trade secrets that can be used for commercial advantage, like there would be between two companies. And anything that's invented under CELMET, the rights to the patents, the rights to the copyright and the code, are going to clearly flow through this CELMET arrangement and be owned by a university or licensed to one of the existing companies. And so that's going to protect anything that's created here from an IP perspective. And so I think there's pretty little risk of someone graduating, going to a company, and being able to commercially exploit something valuable that was created here. Because if it was valuable, the IP is going to rest here. I also think most sophisticated companies hiring people are trying to prevent that from happening. They have intake processes that are trying to prevent IP contamination. So they're basically saying, hey, don't you dare bring any code, from your prior graduate school work, or you work at a prior company. Don't bring anything that's sensitive. And if there's something you worked on that's patented, let us know so that we can be aware of that. So you can't come here and start a process that we're not allowed to use because the patent rights sit with BU licensed to some competitor. It's a good question. I think here there's very minimal risk of that happening.
Do we have to be careful about, I don't know about everyone else, but if we're working on different projects that happen to fall into CELMET category but are not necessarily wholly exclusive to CELMET, what the hierarchy of assigning that to end up being? Does that make any sense?
Well, if it's funded, if you're working on a project that is funded on NSF dollars designated for this project. It's CELMET. Now, if it's, we've actually run into this agreement because some corporate members may decide that, hey, we want to do an extra project. I don't know. Instead of growing cardiac tissue, maybe they want to grow lung tissue. And so all the things we've learned in terms of building scaffolds is identical. Maybe the cell growth is different. I don't know. Anything you do that's under that separate sponsored research agreement, you got to put firewalls up. And I mean, there are a lot of overlap. Where the overlap is, if it's funded by $1 of NSF funds on the CELMET project, we got to call it CELMET, and it has to be available to all members. If it's funded on a separate sponsored research agreement, then it's not.
I think maybe a little bit more into the question is, so for example, the technology that's being developed for CELMET can be used for cardiac tissue, but it can, and somebody should nod, it can also be used for other types of tissue. So if someone is working on, so I think that might be the conflict that you're thinking about, is like if there's a different application that's not under the CELMET umbrella, how does that work?
I don't think there's a field of use restriction in CELMET, is there?
No, there's not. There's not.
So I think it kind of does revert back to what's the money you're using, you know, and that you just need to avoid contamination of, if you're doing industry-sponsored research for Google, don't use that money for a CELMET project and vice versa.
Yeah.
Because the rights flow from the money you use.
Yeah, to be more specific, maybe. So, like, if I'm working on a project that the data is obviously relevant to CELMET in some context, like if I go present to CELMET, I might show that data. But really, that data might be more interesting at a conference that's unrelated to sort of CELMET work. So if I have, like, multiple people that I have to kind of, like, share that information with, I'm going to have to be careful, right, and, like, who I'm presenting to. And what information I'm presenting, and I'm just wondering, like, is that on us to talk to our PI about that individually to figure out, like, yes, I can say this and not this? Because if the dollars were spent in an ambiguous way, how are we supposed to know?
If you're working on a project and you have all these printing techniques for printing on these big screen TVs, big screen displays, even though we're using it on CELMET, it's not proprietary. I mean, it's not proprietary to CELMET, and all the inventions occurred on prior fundings.
Any other questions? Well, you know, I know we got into some technical, you know, issues of the law. None of this is meant to be scary or paralyzing. The point is that, you know, you're dealing with potentially commercially valuable research, and so it's important to treat it as such and just know that there can be some issues, in particular related to public disclosures, and in particular, you know, being careful about how you use it digitally, whether on social media or otherwise, that could harm the commercial potential of it. And so, you know, just be aware of that, number one, and then number two, know that there's lots of people here to help you with these issues. You're not on your own. So whether it's your PIs, whether it's people in the room, whether it's people in your tech transfer office, hopefully this instills you just enough the spider senses to know that, hey, this is something I think I remember hearing about before I could be a foreman. Go ask for help, and there's help available.
Yeah, one other thing, too. There's a couple mandatory things that we have to do in CELMET in order to get renewed after 5 years. One of the things that is looked at very closely is the number of inventions that have been patented and the number of licenses we do. So it's to our benefit to try to protect as many inventions as possible. It just helps us with our metrics. So that's just it's an admin item on the side there, but it does impact renewal.
All right, Nick, you're up. Good luck. Thanks for the good questions.
Thank you, Bryce. Appreciate it.